other requests for the floor on this file. So last but not least, reporting back once again on the copyright in the digital single market, and the floor goes to Mr. Voss.
Thank you very much, Chairman. First of all, last Wednesday in Strasbourg, in the course of the evening, we had an agreement with the Commission and the Council. And what I would like to stress here, when it comes to the 4 hours that were set aside for that meeting, the latter took 13 hours to get through. So I'd like to really thank advisors, assistants, fellow members, everybody, and in particular the Secretariat, because the Secretariat was just doing its utmost to see to it that we had the interpretation, the facilities, the assistance. So thanks so much to everyone who chipped in to see that we really made the most of the morning, afternoon, evening, and nighttime to come to this agreement. Now, generally speaking, Article 13, of course, the value gap article was 1, then the publisher's right, Article 11, then minus 14, 16A, and Article 3A were the ones we spent the most time on, managed to tie it all up in a package. There's some minor points that did require a full day's discussion. So when it comes to the reform of copyright in the EU, when it comes to Article 13, this just implements what already exists or is in line with the case law when it comes to the rules for liability in respect of platforms are being clarified in Article 2, Para 5, that Article 13 does not encompass all platforms. And that's something I'd like to highlight at this juncture, because there's been a bit of disinformation stemming from our house here. So not all platforms are subject to Article 13, rather only those that know full well that they are hosting copyright protected works on their platform. So it's a matter of making public access to copyrighted material when the appropriate measures are taken with regard to uploading that material and making it public. That is where Article 13 kicks in. So we have a negative list to spell out in Article 2, Para 5, that a platform such an open source platform, Wikipedia, online encyclopedias, etc., platforms where the rights holders have uploaded the works themselves, non-commercial platforms, platforms like Dropbox, where it's just a matter of storing something and not making it widely publicly accessible. So dating platforms, commerce platforms, they don't come within the purview of Article 13. So it's just going to be a small circle of platforms that are going to be affected at the end of the day. So on that basis, a lot of them aren't covered here. And that notwithstanding, that's not what people say. They pretend like you're covered in any and everything in the web. So when it comes to the ones that are covered by Article 13 on the basis of our agreement, and this was something that was Parliament was keen on, was the reproduction. So when it comes to these protected works that have been uploaded, they must be licensed. And the utmost efforts have to be made when it comes to obtaining a license from the rights holder. in the event that the platform does not get hold of a license, or something that often happens in the audiovisual sphere is that from the outset no authorization will take place. The platform must again make the utmost effort so that on the basis of the information of the rights holders, the works will not be uploaded. And then there's a third case, as it were, if on the website there are works that have already appeared, and when there is communication by the rights holder and the works are downloaded, the notice and takedown procedure that, of course, we have in the e-commerce directive, then in future they must ensure that those works do not reappear on the website. That's the notice and stay down procedure. And that, too, is something that already exists. So this is as a result of case law. So there's these three steps that I've just outlined, and if those are followed, then the platform is no longer to be held liable. That was part of the Parliament's mandate. We had a strict responsibility foreseen for the platform, and to see this to a happy conclusion, we were more or less obliged, or were open to less liability cases for platforms. And we did make concessions to Council in Article 13, where there's an exemption for the smaller businesses. That's Article 13, Paragraph 4AA. That's another reduction of liability for young or small platforms. And there we've listed the criteria. So we don't want to hit platforms that has a global turnover of 10 million up to 5 million monthly users, and that are not more than 3 years old. So the restricted liability for them also involves the obligation to seek authorizations or licenses from rights holders, and then, of course, upon request of right holders, to remove works. And here, too, we did make concessions to the Council, a user-generated content exemption. So that was something that we thought being in the interests of users who, on the basis of a copyright-protected work, these are gifts of means that those contents may be uploaded. So in the interest of the users, we did take the appropriate steps and tried to see to it that the contents could be uploaded when it comes to review, parody, etc. So we have these clear-cut exceptions where uploading is permitted. So in a nutshell, that's what Article 13 is about. Now in public, there's all kinds of nonsense, disinformation out there, and I do hope that we can turn this into real news. Article 11, there's a publisher's right. That was what we wanted to introduce, and we wanted to have very stringent demands. But given the situation in Council and the majority situation in Council, it didn't quite work out as we'd hoped. So we not only have it the private use and non-commercial use of media material, something we already had, but now there's these excerpts of just a few words, very short excerpts of published media material. That's authorized, but that was something that was something we are quite content with. Now, when it comes to Chapter 3, the so-called minus 14 to 16A articles, minus 14 is a principle. I'll just try to explain this in English.
Proportionate remuneration, also eine angemessene Vergütung.
That was as controversial as could be, especially in the council. And also the major rights holders were concerned about this, but we fought on behalf of smaller artists and to give them the possibility of fair remuneration, to see that that could be secured. So there's a relationship between the artist and the rights holder to improve that. In Articles 14, 15, 16, there's the right to information, and transparency is spelled out there, and then the contractual consequences that derive therefrom. So there's a possibility for mediation, Article 16, and arbitration. So the artists are better off. So that's something we want to insist on, that copyright protected works can't just be used any old way and can't be remunerated just any old way. There were two issues at the end of the process. One, when it comes to the lump sum remuneration for use of a work, and then very much at the end, the different cases that obtain in member states, but we sorted those out as well. Now, just very briefly on Article 3A, the text and data mining is split in two, Article 3 and then in Article 3A. Article 3 really covers what we already had in our respective legislation, text and data mining as a possibility for research institutions, educational institutions. That's something worldwide, basically. But what we did in 3A is, when it comes to text and data mining possibilities, was brought into line with real world possibilities. So we've provided for exceptions here, so that private use or commercial use for text and data mining purposes, it can be done, and it's going to be obligatory in all member states, so there will be a level playing field. But at the same time, we did find the means to secure the interests of right holders who don't want a machine-readable form of their works to be available. Then, when it comes to, well, basically the bottom line, given the difficult situation in majority, as said in the council about the, excuse me, when it comes to the majority position there, it was really tough going, and each time we had to take account of that, and we know what the developments have been since last summer. There's been some very emotional clashes on this subject. So I dare say, I do believe we did manage to find that golden mean, as it were, where in council and a majority we could get a majority. It's tricky as could be, because there were all kinds of conflicting interests here, but hopefully we did find the level where also the rights holders will be able to give their support to this. They probably won't all be on board, but we can take it that we'll have a broad majority, and so we can say that we have worked on behalf of the rights holders. The criticism that's sometimes voiced against our mandate that we haven't been open enough in terms of digital developments. No, I think we did a pretty fair job. It said we've got these exemptions, and we did try to get the balance right. But I dare say, in the main, we tried to put this into writing, but as said, this already exists as a result of court rulings and case law. So these outcries that you hear are not based on fact, I'm afraid to say, and I'll leave it at that for now. Thank you.
Merci, Monsieur le rapporteur.
Thank you, Madame Regner. Please try to be brief and to the point, because there's a lot of members who have asked for the floor, and I hate to cut you off. You have the floor, madam. Thank you very much, Chairman. I had the impression that we had a meeting till 12:30, and that we should really take the time to thrash this out, because this is probably the last opportunity we're going to have to do it. Yesterday we learned that next week there's going to be an exceptional meeting with a view to this agreement being rushed through the Legal Affairs Committee, even though when it comes to the final wording of the trilogue hasn't been made available. So one can't help gets the feeling that it's a matter of rushing this through before there's any public outcries in late March, because even this weekend, once the outcome of the trilogue became known, thousands of people were demonstrating in the streets of Cologne and said, "We are not bots." And a number of groups have claimed that citizens who got in touch with their MEPs by email or on the phone learned or got the impression that they were dealing with bots. So that's a case of disinformation. That's why these were people in the street saying they are not bots. So when it comes to those also who are supporting this agreement, they sometimes have recourse to unfair means. There was a blog post from the Commission where the enemies of the outcome were described as a mob, which I think is really unfair and really flies in the face of what we want young Europeans to have in the way of a perception of how we craft legislation. So a lot of people have taken up an interest in politics and will be voting in May. Now, coming to the outcome itself, in a lot of areas it's become more extreme as compared with what was adopted in the fall by Parliament. In July, the Parliament rejected the Legal Affairs Committee mandate, and it was only in September that there was a slim majority on Article 13 where smaller companies were fully excluded, but that's no longer the case. Now they're excluded if they're younger than 3 years old, and that means, for instance, a discussion forum, even if it's run by a single individual after 3 years, it would have to, well, it would fall within the scope of this article. And given the very narrow majority last time, I don't see how Parliament's going to go for this. Then also in the Parliament's mandate, automatic filters were to be avoided. In the course of the negotiations, I spoke out that we stick to that, but unfortunately the rapporteur didn't, probably also because Article 13 without automatic filtering can't be implemented. And I don't think it's fair to say that a so-called user-generated content exception has been introduced, because it says black on white that only existing exemptions for parodies, for citing reviews, are to be protected Europe-wide, but that's it. So one could say, okay, parodies, quotes, that covers it. No, because the upload filter, they are to decide automatically what constitutes a breach of copyright or not. Can't recognize a parody. So so long as algorithms don't have a sense of humor, it's not going to be any help of users that on paper they're allowed to go ahead with parody if the filter's going to block them automatically anyway. And then something else you said, that this would only affect platforms that knowingly breach copyright. But you mentioned dating platforms. It doesn't say that. It says it's a matter of exchanging protected works. But each individual photograph is deemed to be copyrighted. A dating platform such as Tinder exchanges these photos so that you can meet people in your neighborhood. They're protected, but it's not in the interest of a dating platform that they're going to be uploading the catalogs of Getty or Lord knows what. But people are uploading their own pictures, but they are protected. So there's a misunderstanding here that it's only a matter of protecting material where it's a matter of generating remuneration. That isn't the case. Now, the Wikipedia doesn't have to use any upload filters according to this legislation, but Wikipedia, just like other operators, are caught or hit by Article 11, the publisher's right article. So they will be affected by that, and that's something that's failed in Germany. And when it comes to search engines, it was restricted basically to that. So Article 11 covers all online services and goes well beyond what we've had so far. The fact that the involvement of journalists, that is the case. Only freelancers are to benefit from remuneration under Article 11, not journalists. So the International Journalist Association has spoken out against the outcome of the trilogue. And in any event, there wouldn't have been any money flowing, because we know that all that's led to in Germany is remuneration to the tune of €0. It means €0. So the total buyout contracts, when it comes to proportional remuneration, are now to be allowed expressly. Well, that was the whole point of the European Parliament when it comes to fair proportional remuneration. There's total buyout possibility to be terminated insofar as possible. So I would really call the committee not to give its endorsement to the outcome of the trilogue, and it goes well beyond what we mandated in September. Thank you.
Merci, Madame. La parole est...
Thank you. Mrs. Kaufmann.
Präsident.
Thank you, Chairman. I'd like to take advantage of this discussion to put a few questions to Axel Voss, the rapporteur on Articles 11 and 13, because what has just been said, there's going to be an exceptional meeting next week, but we don't really, we haven't seen the full wording. Whence my questions. On Article 11, this is the matter whether it's really that clear when it comes to the publisher's rights that the authors, the journalists, actually will be entitled to fair remuneration when it comes to online transactions. Or when it comes to the wording of Article 11, does that mean that publishers, when it comes to remuneration on the part of journalists or authors, to be ruled out on account of existing contractual agreements, or the terms thereof? Article 11, I have another question. the private or non-commercial use of press publications carried out by individual users. So that here the publisher's right shall not apply. My question is, what is the average internet user allowed to do once this goes into effect? For instance, when it comes to press material, may one share it if one is not trying to make money out of what he or she is doing? Article 13, Axel Voss pointed out that there are exceptions for companies that are younger than 3 years, fewer than 5 million individual users. So this exemption for startups. What I would like to know is how did we end up with that? What was the basis? What is the knowledge underpinning this particular exemption? And then secondly, are there any statements as to how many startups are going to be affected by this, i.e. that they wouldn't be subject to the provisions in the aforementioned article? Then I also, further on Article 13, what Mathreda just mentioned, quotes, parodies, etc. In Article 13, there's paragraph 5 that says that the member states shall ensure, that in all member states it is established that quotations, criticism, review, parody, caricatures, etc. shall be possible. Well, I can't help wondering, how is that possible? We have a uniform set of rules when at the same time it's the member states who are responsible to transpose it in the member states. So I'd appreciate enlightenment on that one. Then something else, that there are different situations in the various member states, that's going to be the future, and the existing fragmentation that we have thanks to the InfoSoc directive is going to just keep on going. Thank you. Mr. Wojtka, please.
Vielen Dank. Wir erleben seit dem
Well, since the conclusion of the trilogue negotiations, I think we've been going through something that's actually rarely seen. It's a debate that's been going on, particularly among young Europeans. And this discussion has even led to around 20,000 people demonstrating against this reform of copyright in Cologne at the weekend. And what I'm pleased about is that young people are getting involved and interested in politics. But what I'm not so pleased about is the fact that there are colleagues even here who are insinuating that signatures against this reform are being generated by bots. And that suggests, or is trying to suggest, that young people are being used to try and go back on this reform, or even don't exist at all. And I think it's very important for us to make it clear that it is not basically an angry mob trying to get something done here, as the Commission suggested in a blog post. This is concerned young people. And these are people who are concerned that a part of their culture is going to simply disappear. And given that, that is a major concern, I think. There are lawyers who have looked at the text. We haven't officially actually seen it yet, so it's not a great time to have a debate. But nevertheless, there are people who have looked at leaked versions of the text, lawyers, and they say that there is a concern that the rules that have been adopted now will be to the benefit of, will call in question, the business models of platforms such as Twitter, YouTube, etc. And I would say that these platforms are actually essential for our information-based society. We shouldn't make the error of simply ignoring these platforms. We can establish rules which they have to adhere to. We should do that, of course. But it's mainly young Europeans who use these platforms, I think. And if they believe that we are doing something that damages their way of life, then that means this is a major error. And you can come along and say, well, there are some platforms that aren't included pursuant to Article 2. And that's true. I mean, every platform that isn't YouTube and screamed loudly enough got an exception here. That's true. But those who don't have an exception are future platforms that we don't yet know about. They're not dealt with in the rules. So, I mean, you might well have a startup now which in 3 years is so successful that then they need to introduce this filter technology, and they have to get hold of that technology. And who do they buy it from? Large American businesses which are already using these things or developing them. So basically, people are saying, okay, young people are being used by Google, they're being used to demonstrate against this, but why is Google interested in this? Because they've already got these upload filters, they're using them already. So I wouldn't say this is a mob that's simply being used by big business. These are young people who are worried about the future, and we should recognise that. When it comes to Article 11, I'm concerned that serious newspapers will try and sell the licenses. Platforms may well not want to buy them, and basically that'll mean that serious news sites will disappear from these platforms and we'll be left with fake news. I mean, we're still going to read serious media, I suppose, but the problem is that there'll be more linking to content that isn't serious, and that's the problem with the linking issue. And then just to conclude, I think there should be a genuine exemption for user-generated content. I think that would have been essential to be able to vote in favour of this deal. I mean, we have basically gone for the coward's way out. We've said that there are exemptions that will be possible. We should ensure that these exemptions are actually exemptions, and the text doesn't say much about that, for example, in terms of user-generated content. We've discussed this with IT experts. People, and even they are saying at the moment when it comes to upload filters that they don't know how that's going to work. And I think that's also a major problem here.
Merci à vous, Monsieur Volken. Monsieur Anderson.
Thank you, Mr. Volken. Mr. Anderson.
Thank you, Chair. On the question of bots, I have proof that at least the people that were sending me email during the summer were Swedes. And I can prove this because I included in my standard email that was an automatic reply, I included a YouTube video of me speaking against Article 13 and Article 11. So when people opened the email, a fraction of them actually wanted to see the video. And I have got the statistics from this, of course. But we noticed a small thing. You remember there was some sort of big football tournament during the summer. I think it was the European. Was it the World Cup?
Yes, it was.
Football is really not my thing, but it was the World Cup. Thank you, Virginia.
You're welcome.
When Sweden played football on television, the rating on my YouTube video dropped by 60%. Now, I am quite confident that bots do not stop reading their email because Sweden plays football on television. But Swedes do. So, and it's, of course, noticed that people were sending 2 emails. That's the kind of thing you notice when you read your email. So, of course, there was a number of duplications. But basically, this is a real, genuine citizen concern where lots of people are actually contacting their politicians because they care about this issue and have studied it. So please take the people seriously. Also, I find it very worrying that this proposal might pass. It would seriously damage the internet as we know it, and also there's a high risk that it would hobble the EU economy because it would make life very difficult for companies that would like to use the possibilities of the internet to have comments and share things. Companies such as TripAdvisor and all its competitors, companies that have forums with advertising, small business people using their home pages in order to gain traffic. A lot of people will be seriously impacted by this, and a lot of people are going to get angry when they find out the EU is stopping them from linking and that the EU is stopping them from uploading things that actually in some cases it's even legal to upload, but there is a bad law, badly written law that prevents them. Now, I am a lot more Eurosceptic than most people in this room. I'm a pragmatic Scandinavian center-left Eurosceptic of a strain that is very, very, very alien to the British. I'll refrain from commenting on them. But basically, I am very dissatisfied with the way the EU is functioning. There is a democratic deficit. And I would like to thank Mr. Voss for all his hard work in demonstrating to the world and to the youth of the European Union that the EU is democratically dysfunctional, arrogant, and subject to corporate capture. Thank you. You're doing my job.
Merci, Monsieur. Madame Rosière.
Thank you. Mrs. Rosière, please. Well, I'm quite surprised to hear those kinds of comments. Regardless of our differences, we rarely hear that kind of thing in the House. But yes, there has been a massive lobbying effort, mass manipulation, hijacking the public debate, and this has been carried out on a massive scale by private interests. I mean, we've seen this insidious form of lobbying going on for months now. And here I'm talking about the FANGs, Facebook, etc. I mean, it's not hard to find why they're doing it. You have to see that they benefit from what they're doing. And okay, it's true, many people have been mobilized by these fake messages which have been going on for months now. And this is all about dominating digital communication channels and social media. And we're not necessarily the people who suffer from this online intermediation, because of the internet is now where people access their cultural goods. But artists are creators, and that's what they do. They shouldn't be thinking about having to market, etc., their goods. And this is what we mean by the value gap. The value, because when you have artistic works being distributed by media channels, and you have these digital intermediaries who gather up and link to these works, and then the benefits don't actually reach creators, and that means that European culture as a whole suffers economically, but also our cultural, the creative energy as well, because at the end of the day it's the creative people who don't benefit from their works. Now, I would welcome the fact that one of our red lines, Article -14 as it were, which deals with the issue of remuneration for artists, is in the compromise. That was something that we wanted to see in the compromise. Obviously, we have to look at the text in detail, but the fact that that is in the final compromise, I think, is a victory, and I'm very pleased about it. Because what we need to be concerned about here is artists. I mean, at the end of the day, if artists no longer can create, you can have all the online intermediaries in the world, but the works won't be there anymore. So that's with regard to the content and the commitment that we need to have vis-à-vis our European culture and our European artists, because at the end of the day, I prefer to support European artists than American digital businesses, and they really have been scandalous in the way they've got involved in this debate for months.
When we have these scandals, we sometimes overlook the fact that there are victims behind all of this, victims that have suffered themselves. So this is a photo exhibition that shows the faces of the victims. We're all convinced, but it's one more opportunity for us to be even more convinced of the important role that whistleblowers play and the role they play in maintaining democracy. So Tuesday the 26th at noon, next Tuesday. Thank you.
Thank you very much. No other requests for the floor on this file. So, last but not least, reporting back once again on the copyright in the digital single market, and the floor goes to Mr. Voss.
Million times. I mean, it was the same thing with the General Data Protection Regulation. The internet people said that they were going to have to shut down because they wouldn't be able to protect people's data. I mean, and regardless of what they said, the internet is nevertheless working. So you've got these digital businesses running these campaigns online. You've got certain website addresses that have .eu as their domain address, but actually if you look behind them, you'll see they're hosted in the United States. I mean, you've got these tweets, 71,000 tweets coming from right across the European Union, over 80,000 coming from Washington. So, you know, what's going on there? Then we've got YouTube distributing false information to all YouTubers to get them to believe that what we vote on is going to stop them making their videos in the future. That's obviously not true, and it's serious as well, because the fact is that young people do get politically mobilized, as colleagues have said, and that's a good thing. But the problem is that today, an internet giant such as YouTube is using young people to lobby on its behalf, and it's doing it by feeding them lies, and that is disgusting. I think that is very serious when it comes to the quality of our democratic debate. It's a betrayal of our young people. So the extent of the mobilization, the violence that we've suffered at the hands of these internet giants actually shows that we're on the right path, because these big internet businesses are running scared, and that means that finally we'll be able to ensure that artists prevail over the internet giants. Thank you. Thank you, Mrs. Hautala, please.
Thank you very much. I'm of course a cool Scandinavian, and I'm a totally Europhile member of this committee. I just like to express my concern that there is such a division in this parliament and in the public opinion about this. And I am convinced that it would be very helpful if all the rapporteur and the shadow rapporteurs would follow the new rules of procedure, as Julia Reda has indicated, and publish to whom they have talked during the legislative procedure, because now we are really coming to the close. And it's not difficult at all. You just have to attach a sheet to the report, and that's it, while waiting for the online infrastructure to be put in place by Parliament. Now, what worries me indeed is that we are having this debate basically in an empty room, half-empty room, I would say, on one of the most important legislative works done during these 5 years that are now rapidly coming to an end. And this debate is not really what it would be worth, because we don't have the text to discuss. And what worries me, what I have read from media reports, is that there are some very obscure definitions and wordings, and I am afraid that the courts will have a lot to do to give the right interpretation. For instance, to these, how can a platform prove that they have done their best efforts to eliminate copyrighted material, and what does it mean, individual words and very short texts? I mean, a legislator should not use such expressions, and then it's only the courts that can try to examine this, and it's be very unfortunate. And I agree with everything that has been said by Julia Reda and Max Andersson. Also, the exclusion of these startups from the obligations is really not meaningful, because very few can escape these three criteria: turnover less than 10 million euro per year, less than 5 million monthly visitors to the websites, and the age less than 3 years. So it was correct that one of the colleagues asked how many startups actually escape these obligations. So indeed, we are not bots, and I'd like to conclude by saying that I'm deeply offended by this propaganda that the Commission published at the end of last week. Also, Julia Reda referred to it, by trying to propose that everything in this compromise is fantastic for all the parties, everyone, and that there was a mob trying to disturb this work. And it is not surprising that the Commission had to withdraw this article from the website with a very awkward explanation that, in fact, it was not the problem what was written in the article, but it was the problem of that someone would misunderstand what has been said and that would not reflect the opinion of the Commission. This should never, ever happen again. So I hope we will have a lot of attention to this work on the way to the plenary, and next week will be, of course, decisive for the vote in this committee.
Monsieur Zwiefka. Merci, madame.
Mr. Zwiefka, please.
Bardzo dziękuję, panie przewodniczący.
Thank you very much, Chair. Well, we have another episode of this debate on a very important topic. I wanted to say some things, but after what Mrs. Rozière said, I need to shorten my presentation, because I fully agree with what you said, Madam. Now, as regards what the previous speakers have said so far, well, what we witnessed was an exceptional attempt at raising the stakes. The emotion was really quite intense. It was before the summer break that we received results of research on American capital. American money was engaged in creating various propaganda outlets and activities in Europe. Oh my God, could we have the same impact on the American body politic? Could our companies really have so much say on the American market? This is really incredible. But first things first. Ms. Reda said that it was by a small margin that we received support for our negotiating mandate. All right, 438 in favor and 246 votes against. Is this a small margin? Really? Let's be honest with each other. So this is an example of manipulation. I am very happy that young people are involved in this whole process of defending not really their own interests, but I would agree with one of the colleagues who said that we are trying to defend part of our culture. Internet is part and parcel of our culture. but not only of the young generation now, but also of my generation. But how are we driving our young people to take such a decision? They do not know the contents of our documents. They do not know how our debate develops in the parliament. Well, they get bits and pieces of information, and those bits and pieces shape their decisions. I remember how propaganda was used against my country. Young people in my country were shaped, or at least attempts were made to have our young people in Poland to go to take to the streets and do something. So it would be worthwhile really to see what the American technology giants are doing now, how they are trying to shape our processes in the parliament before the vote. Now, bots, the so-called bots. I don't like this word. I don't like to talk about bots. I like to talk about automatic sending of certain messages. Well, Polish members in the parliament got two messages, no more. So how did the people get those two texts? Those two texts were identical between the thousands. I don't know how many people who sent us messages. They were identical down to the last comma and point. Now, with Julia, me and Julia, we went to the Silicon Valley in America, and we talked about startups. What are startups? They are small companies at early stages of development, and they need assistance in order to help them. So, how long is the startup phase? How long does it take to start up? Well, 1 year. Basically, the Americans told us that after 1 year, those companies either develop and are successful, or they go bust. So, after, I don't know, 3 years, a company should be deemed a regular SME on the European market. So 3 years is really, that's good enough. Julia Reda also claims that during the negotiation, the rapporteur didn't care enough to extend the scope, extend time limits, and protect our citizens' interests. Well, I think that in our work we should be driven by the interests of the user, the end user, but also we have to defend our culture. We have to support those companies which are good. Please don't spread this misinformation to the effect that somebody will not be allowed to write a review of a product or test or something. If I have prepared something myself, my own work, I can publish it wherever I want, however I want, and nobody will stop me. So, in no other European document so far was an end user described so well. All that is clearly laid out. Article 13, when the mandate was negotiated, Article 1 was on 1 page. Now it covers 4 pages. Why? Because we have more new elements, better descriptions, better definitions. During the negotiation, member states went to great lengths in order to ensure transparency and clarity of these regulations. I do agree, of course, that even as of today, not everything has been foreseen, predicted, and taken into account. But what lawyer can predict everything? some colleagues are saying, well, we want to put this document in the dustbin because it has failed to foresee what will happen in a couple of years' time. Well, I think we should finally adopt this document, and this way we will prove that we care about our end users, our creators, artists, our culture, our identity. And please, please, let us not be deceived by those who have a lot of money and they want to make even more money off us. Thank you very much.
Merci beaucoup, Monsieur Zwiefka.
Thank you very much, Mr. Zwiefka. Mr. Le Breton now, please. Thank you very much, Chairman. We've seen a massive struggle between European creators who legitimately want to receive remuneration for their works that people look at online, and also the large internet companies who are saying that these works will disappear if they're not allowed to carry on doing what they're doing. Well, I don't believe that. I fully defend European culture against these big businesses. And let's not forget that these aren't only American businesses nowadays, they're becoming more and more Chinese as well, because the numbers of these businesses are expanding. So I think this is a major challenge, and what we have to do is defend our culture vis-à-vis the United States and China. From this point of view, I think the trialogue will have produced a text that will consist of a step forward, because, okay, we may well have reservations on various points it contains. I don't think there's any doubt that our creators are going to be better protected under this text than they were previously. So I see that as a step forward. Technically speaking, things perhaps won't be perfect. I mean, I listened to Mr. Voss, and he's doing everything possible. But nevertheless, there are some good things. These derogations for startups that have been around for less than 3 years, I think that's a good thing. 3 years, I think, is enough time for them to develop. And then for the rest of it, well, goodness me. I mean, there are some vague provisions, but I'm sure the Court of Justice will provide the necessary clarity. I think we have to look at the text that is emerging. We haven't seen it yet, that's a bit annoying, but I think we have to see it as a first step, which will be decisive, and then which will lead to further progress later on. So we'll have the court's interpretation, and then subsequently, no doubt, given the imperfections that have been raised, there'll be a new text, but that'll be for our successors, of course. In any case, I'll be pleased to have been involved in a combat in favour of European culture under this parliamentary term. Thank you. Thank you, Mr. Le Breton. Mrs. Rader now. I think you wanted to come back. Please try and keep it brief. Yes, thank you very much, Chairman. Well, I wasn't going to take the floor again, but then Mr. Zwiefka accused me of manipulation and lying, and so I wanted to set the record straight. I said that the vote on Article 13 took place in September and was close. 366 in favour, 297 against. Those were the figures. Less than 70 votes difference in a parliament of 751 members. I think you can describe that as close without being accused of manipulation. Obviously, more members voted to go to negotiations at the end of the day, but also because they falsely believed that their criticism would be raised and dealt with during trilogue negotiations. Actually, the opposite happened. The text wasn't improved at all, and the exception for SMEs was further weakened. For me and for many others, this exception was never about startups. There are many small businesses in the EU that want to stay small, and that's fine. You could have a platform run by one person because it's their hobby, and they want to exchange views with other people who are interested in the same things as they are. I mean, I can't see how they're going to violate EU copyright rules, and I think it's fully inappropriate to say that they'll be treated like YouTube after 3 years. The internet world is not only made up of large internet providers and platforms and startups, and then there's the accusation that I lied when because I said that you're not allowed to post comments. I mean, I didn't say that it's not that you're not allowed to post these things. It's that you can't post them because upload filters can't differentiate between different content. They're saying, well, is some kind of copyrighted content being used? And then what's being uploaded is blocked, and the person who wanted to carry out the upload has to complain. But if you've got a live stream, for example, what's the point of having that allowed 24 hours later once it's been shut down? Then you can't broadcast anything live, can you? And then finally, on something with regard to transparency and clarity here, Mrs. Hautala's quite right. We have to look at which lobbyists people actually met. I have published all my meetings with lobbying groups. Others have also done it. The Commission and Corporate Europe Observatory have analysed that. I mean, I think these people are definitely on the side of big American business. And they were saying as well, though, how large businesses tried to get around the data protection rules as well. But in any way, the analysis has taken place, and the result has shown that the vast majority of meetings took place with media businesses, not with internet giants. I myself met with more media businesses than internet giants, and I don't think it's a secret that that was the case for other negotiators too. But I don't think when you've got a 4-page article you can talk about clarity and transparency.
Merci, Madame.
Thank you. Colleagues. You're all aware of my position, I think. I've been fighting for it for 15 years now, and that's meant that I could work very assiduously on the text when we finally got a proposal from the Commission. And this is the text that we're currently discussing. I had put myself first on the speaker's list, but Mr. Svoboda asked me to replace him in the chair, so I decided not to take the floor first because I wanted to let everyone have their say. Now, for several years, I've been wondering whether if instead of saying that the internet is free, the free internet, we talked about goods, well, would there be many people calling for goods produced by people who are paid a salary free of charge? Would there be many people asking for that, for people to be able to have free access to these goods, so that, for example, you could go into an Amazon warehouse, look for what you want, help yourself, use it, and not pay anything for it? I mean, I don't think anyone would be calling for that. We need some kind of organisation in terms of production, remuneration, and consumption. It's now been 20 years almost, and we haven't managed to defend goods which are far more important than, for example, a car, a cake box, or whatever. There's some very bizarre propaganda going on. Mrs. Rosier got annoyed, and she's quite right. I mean, how has it happened that we have managed to get some young people's backs up to this extent? I mean, not all young people, luckily. I mean, everyone knows that everyone who works should be paid, but it seems that people who are creating perhaps goods that are more intangible, so people who express ideas using a pen or a computer, I mean, it seems that they shouldn't be paid. I don't think anyone can reasonably say that these people shouldn't be allowed to eat, to pay their rent, to feed their families. I mean, you can't ask people to go to work during the day and then write songs at night. I've looked at the figures. Over the last 5 years, there's not one of these large internet businesses whose profits have not increased year on year. We've heard a lot of complaints here and arguments in favour of these internet giants, but the fact is that these are businesses that are making massive profits, and they're also involved in a great deal of propaganda. I mean, Europe was great on the general data protection regulation, and I find it hard to believe that we're not as good on collective data, and that includes timetables, hotel reservations, all sorts of things. But there are things that are much more valuable than that. The press is going to wither and die. Let me reiterate what I said here a few months ago. In France, we saw that between January and August 2018, 7% of turnover left our media companies and went into the digital world. And there's no press business in Europe that could deal with that over a 5 or 10-year period. So that could cause a problem. And the fact is, creative work doesn't take place during a couple of days' holiday, at the end of someone's working day, during a bad time, whatever. It's not then that artists are going to create music, literature, or whatever. Art is a full-time job. We have to have people remunerated properly. Okay, yes, young people, and Mrs. Rader, Mr. Anderson, they've got used to this free consumption. This is what we've done. But I think what we really should do is educate these young people. We should tell them that every object, every good, every work of art, every press article that they consume has to be paid for by someone. They're lucky enough not to pay for it themselves, because we're asking large American technological companies to pay for it. So, you know, this is a great moral position. Then there's this issue of filters, the so-called filters problem, but there are no filters. That was withdrawn from the text. But there is a need to point out whether a good can be consumed free of charge or not. But Mrs. Rader, I mean, if I go and get your wallet or your jacket, I mean, they're not free of charge. They belong to you. But what you're trying to do is to ensure, well, you can laugh if you want. I didn't laugh when you were talking. Keep laughing. You'll see what the consequences are. But I think the fact is that you are helping these businesses that simply sweep up content, and then do they distribute it free of charge? Is that the case? No, they make a profit. And do the profits go back to the creators, the artists? Do they go to the press, which is currently dying off? And, you know, you need the press to have a healthy democracy. What do you need? You need the executive, you need an independent judiciary, and you also need an independent press. But what's happening to the world's chief editors, YouTube, Google, etc.? Good news, bad news, false news, rumours, violence, and they carry on making money out of this. And are we not going to morally reflect on this? In Europe, we've set up this project so that we can all live together. We've achieved an appropriate level of civilization, but are we going to simply let barbarians sweep it all away? None of you would publish on your networks what they publish on theirs with the excuse that they're neutral, you know, paedophilia, pornography, all kinds of terrible things. So there's a moral issue here. Okay, the text's not perfect. None of our texts are perfect, I don't think. We're human beings apart from anything else. But also, since I've been here, so over the last 15 years, I've never seen this level of violence aimed at a legislative power. There's also this violence being levied against the Commission and also member states. They've all been infiltrated. I mean, let's not forget that some member states who are against this have banks where large American tech businesses put a lot of money. So are we going to bow to the face of that violence? I mean, everyone's got to draw the logical conclusions and then decide what they want to do. But what's happening is a terrible thing. This propaganda has now infiltrated the three institutions. This is something that I've never seen before. It's even got into the interinstitutional dialogue. It's a little bit as though Google went into a Swedish cabinet meeting and said, there's a tax decision that I don't like there, you can't take it. But actually, in Strasbourg in October, it was Google. And how can we accept this kind of thing? We've developed the protection of personal data to an extent that makes Americans jealous. It's something they want as well. Well, I would say that this text is a good first step to provide rights to artists, to creative people. It's a good first step. And what I'm not going to do is say what I think is good about it, because the rapporteur and other colleagues have already done that. But I think this is a serious business that we're dealing with. And history will judge us on what we do. I don't think we should be destroying what provides the vitality of democracy. And I don't think it's a coincidence that this is going on here, that certain comments are being made in the United States, that the Chinese aren't too bothered about it. The fact is that we may well see our freedoms destroyed by propaganda, by capitalism, and by the ideas behind them. In the United States, in Congress, they're wondering whether they shouldn't take Google apart. I don't think we should be helping Google. Mr. Anderson, you wanted the floor, please.
Microphone, please.
Thank you, Mr. Voss, for reminding me to turn on the microphone. Thank you. I shouldn't have laughed at the speech of the chair, but I do remember watching his website.
Ça n'est pas grave, hein, du tout.
It's not that serious.
Well, it was a lack of courtesy from my side. But I do remember looking at Mr. Cavada's website during the time when freedom of panorama was not enacted in France, and seeing a picture of the European Parliament, which was actually a copyright infringement. And considering the fact that Mr. Cavada himself is infringing the actual copyrights, when he is comparing the removal of freedoms and the possibility to make actions that are legal today, such as linking to websites with news, such as uploading material that is currently legal and that material that will be currently legal in the future, but filters which will be introduced widely, filters that are faulty, that will make it impossible to upload things that are legal. When Mr. Cavada is comparing that to the stealing of someone's coat, I think he's mixing up two very, very different debates in a moralizing way that is actually contributing more to confusion than to clarity. But of course, it is wrong of me to not be stone-faced, because that is the way a politician should be. Thank you.
Petite question, est-ce que vous avez...
Just a short question. Are you suggesting that my website had a photo that wasn't covered copyright? Is that what you were saying?
vous ai mal compris.
Or perhaps I misunderstood you.
Yes, your website committed a copyright infringement.
Pas du tout, c'est une photo libre de droit qui appartient.
No, this is a Parliament photo that doesn't have copyright, and they allowed me to use the photo. Thank you very much. Rapporteur, I think that you have the floor now.
Ich danke zunächst einmal.
Well, let me begin by thanking you all for the very comprehensive debate that we've just had. It's a bit unfortunate when we get to the stage when we're just trying to discredit each other. I think we should perhaps discuss the content of this rather than attacking each other. And perhaps we should look again at what this actually comprises. I mean, the question is, are we going to be able to protect copyright in the digital world, and are we going to be able to have the same model in terms of intellectual property, etc.? So that's one question. And then in addition, we need to ask ourselves to what extent respect towards other rights and other people can be guaranteed. The issue as to whether copyright is still relevant was not one that arose in the entire discussion, neither by users, nor by platforms and businesses, nor by members of the European Parliament, and nor was this issue raised by copyright holders, of course. This issue has never been raised. Everyone believes that copyright is important, and everyone is fighting in favour of copyright. But the trouble is that if you say yes to this, if you answer yes to this question, you have to draw the appropriate consequences and try and ensure that these consequences apply in a digitalised world. And that's what we're trying to do here. That doesn't mean that there's just one fundamental rule that is valid, i.e. The freedom to express your opinion, but there's also the right to ownership as well, and that's what we're trying to balance here. Yes, there are issues perhaps in certain marginal areas where such and such a right is not respected or whatever, and I can understand that, but the point is to try and balance out these two basic principles, as I've mentioned. We've heard the accusation from people who were involved in the process right from the start that this is going too fast. Well, no, that's not the case. We wanted this concluded by the 3rd of December, then we wanted it concluded by the 21st of January, but for whatever reason we couldn't conclude on those dates. And let me recall to colleagues that our last official meeting during this parliamentary term will be taking place on the 18th of April. So that's 8 weeks, I think. So we have to look very carefully at this. If we want to conclude here, we need to be disciplined and decide when we can vote, for example. We need time because there are certain procedures that are out of our hands, that are in the hands of the Council, that take time. And if these are fully exhausted, then we're really going to be very short on time. So as far as possible, I would call for us to hold a vote next week. Now, the question on the text, I can understand that those who weren't involved in the process want to know what's in the text. And obviously, we could send out an unofficial version, but the secretariats of the institutions are working together, and they're trying to get an official text out as quickly as possible. I mean, there's no problem in providing an unofficial text if that helps. But this accusation that the text doesn't yet exist, and hearing that from someone who's been involved in the entire process and knows exactly what we've adopted, I mean, you know, that really is a bit ridiculous, I would say. Now, moving on to the content. Has the content become more extreme? In the definitions, we now have an exception for micro and small enterprises. And there are various criteria now, so it's worded slightly differently. Okay, fine, but we've also introduced a proportionality test. So businesses that have a global turnover of 11 million or 5,001 users a month, well, they're not going to be treated like big businesses anyway. So we have balanced all of this, size, users, etc. So that's not quite true, that criticism. We have worked here to ensure that this still works. And then moving on to what Mrs. Kaufmann said with regard to how we got this exception. Well, in our mandate from the Parliament, there was an exception for businesses which have an annual turnover of up to 10 million. And then that was disputed in Council because two large member states were at loggerheads, and we had to try and solve that. One member state wanted this to be dealt with in Article 13, and another member state wanted smaller and earlier stage businesses to be treated differently. So then we agreed on this criterion of 10 million. That goes back to a Commission recommendation, I think. We originally wanted that in. And then the other two criteria come from somewhere else. And people basically thought that that was a sensible way to go, because we shouldn't forget as well that small platforms, however small they are, can be extremely damaging when it comes to copyright protected works. So that's the problem, and that's what we're trying to prevent or limit as much as possible. So now we have to decide, well, then we had to decide whether we wanted this or not. The situation in Council was very difficult because of that dispute that I mentioned, which lasted 3 weeks. That cost us a great deal of time. And the situation was that if we had wanted to change that again, then there would have been no majority in Council. And it's difficult to get a majority anyway in Council. So we had to decide whether we wanted to move forward to try and come to some conclusion or not. And that's why we tried to take certain things out of the definition. There are some people who come under the e-commerce directive anyway. So some of these exceptions are no longer included in Article 13 because they're in the e-commerce directive. The e-commerce directive deals with sort of passive platforms, as it were. But the problem is that if Article 13 disappears, then active platforms are no longer covered either. So on the Parliament side, we tried to ensure that this would be limited to ensuring that copyright holders would have civil law mechanisms to continue to enforce the copyright. So that related to the discussion on this copyright.
That's why when it comes to that criticism that it's all become more extreme, no way. We tried our utmost to find the right mechanisms, and proportionality is there. Upload filters aren't mentioned in the legislation. That's a practical issue, really. Those who have a business model where the users can upload basically whatever they want, and the user, him or herself, don't pay any attention to whether a work is protected or not. So that's why you have to shift the responsibility to the platform. If it's not going to be the users are going to be held liable, then it's these operators who are making those huge amounts of money because they can assess the data and they have the means. So I think it's warranted to say the platform now has a responsibility because they're making loads of money with this, and that's why they should go ahead and license, because they're making money with the works in question. I think that's perfectly warranted. As to how it manages that responsibility is its choice. They've got the business model involving those hazards. Now, if as a startup, I open a new restaurant, I say, hey, no, I don't have to comply with hygiene rules. I'm just a beginner. No. And this, when it comes to the responsibility in connection with this business model, bringing those two into line. So it's not just a matter of responsibility for infrastructure. And I don't mind reiterating it. They're making loads of money with this, so it makes sense. When it comes to the definitions, who's covered by Article 13, I think it's pretty clear cut. I mean, we keep hearing time and time again the dating platforms should be covered or will be covered. Total nonsense. If there was a copyright protected work that turned up on a dating platform, it wouldn't be covered. And those who upload pictures of themselves are rights owners. So implicitly, they're giving their assent to that model. So when it comes to the definitions, they do the trick. And dating platforms are not covered. That's, I said, nonsense. Now, Article 11, what it says in there loudly and clearly, journalists are involved. There's no distinction between freelancers or contractual employees or whatever. What council did and what gave rise to perhaps a misinterpretation is that in the recital, all it says now, because the member states stress their civil law mechanisms, that those mechanisms shouldn't be undermined. So as I see it, there's been a totally wrong interpretation drawn from that. One says, well, this means that those who are already employed, etc., won't be affected. No, that's not how Article 11 works. 0.5, whatever. I'd be happy to get it out for you. But that's in there loudly and clearly. All the journalists are in there, and there's no distinction between employees and freelancers. Now, with regard to private use, citizens may use press articles and may upload them also to platforms. So the platform doesn't have to grant a license or issue a license because it's an authorized upload. As legislators, we give individuals the possibility of having recourse to this article, i.e. to upload things privately. If you, as an MEP, are to be deemed a private individual or not is a different issue. But you can always make a link to that fact. It's just a matter of you can upload the whole text, and without the user being linked to the source, maybe as an MEP, questionable or perhaps not on, but as a private individual, you may do that. Private use is what it says. Then there was something else. Yes. Uniform application or full harmonization, you had an issue there. Now, first of all, copyright law, as it exists. It's as fragmented as could be throughout the EU. Some have exceptions, others don't. So the freedom of panorama, views, I mean, there's different takes in different member states. So it's as different as can be from one member state to the next. And that's why here we have an exemption for quotes, parodies, caricatures, but that is meant to apply across the board. And of course, there can still be some border cases, but one can say, yes, this is mandatory in all member states. And that does mean that there is a similar approach. And of course, this is a directive. And it's a matter of the member states achieving those goals by the means they deem most appropriate. So when it comes to using a directive, you're never going to have full harmonization. You're quite right. It would have been nicer in the digital sphere to have a fully harmonized regulation. But politically, that was never going to fly, because the member states are very proud of their own traditions and the way they deal with copyright, and they wouldn't have played ball. Then when it comes to lobbies, exceptions for platforms, no, this wasn't the result of lobbyism, unless what the term is meant to refer is the opinions of fellow MEPs. And when it comes to dating platforms, Wikipedia, Lord knows how long we discussed all those to see which platforms should be covered and which shouldn't be. And basically, it's always just a matter of getting hitting those platforms that know they have protected material on their platforms. And there's got to be a certain number of protected works that are being hosted there. So even if you have a platform and somebody uploads something, Article 13's never going to kick in. We're talking about a given number or amount of protected material. So, I mean, it's all spelled out here when it comes to all our exceptions. We didn't think it made sense. This has nothing to do with lobbyists or activists. We sat down and thought, which ones do we want to cover? Whence the definition? And that's why I do believe we did give this due consideration, not as account of any lobbying, and also Wikipedia. We came to the conclusion, yes, this is a platform that's accessible to one and all, and you can learn things, you can educate yourself. We didn't want it to be affected. That's why there's an express exclusion. As I see it, even the definition excludes them, but we really wanted to say this, as said, loudly and clearly, and that's why we drew off this negative inventory. Then a TripAdvisor isn't affected. TripAdvisor has nothing to do with Article 13. As to whom one has been talking to, Heidi Hautala mentioned that. I had the feeling I talked to any and everybody. And if somebody wants me to list everyone, the platforms, the petitions, the petitioners, I was talking to them. I really did my utmost to talk to people from every quarter. Now, when it comes to the exclusion of startups, Ms. Hautala had commented on that. If you look at the way Article 13 works, these are active platforms that host protected material on their sites and know it on their platforms, and you can't say a general exclusion would apply. I mean, had we dealt with this in the definition, that would be different. But here, these startups only enter the realm of Article 13 if they meet the requirements in Article 2, Para 5. I'll leave it at that for now, but I do hope that I've given you enough information so that it's clear to everyone. Thank you. Thank you, Rapporteur. 2 bits of information.
So the Secretariat will give us some useful information.
Thank you, Chair. The joint IMCO jury vote is going to be held tomorrow on as of 15:45. This is the vote on the results of negotiations on the contracts for the supply of digital content. The extraordinary meeting of Fury is planned for Tuesday, 26th of February at 3 o'clock, and the next committee meeting will be held in Brussels on Monday, 4th of March at 3 o'clock as well. Thank you.
Il me reste à vous remercier.
I'd like to thank you very much for being so involved in all of this, and the chairman kindly thanks the interpreters. These subjects are extremely technical and detailed, so perhaps the work was even more difficult than usual. Thank you.